Hello, everyone. Welcome to Internet Law Review. Today, we're here with a story about how you will be able to more easily print a firearm in your very own home in the near future. This is Defense Distributed versus the United States government, and this relates to a settlement that was recently reached in an ongoing lawsuit between the parties. So we're going to discuss a little bit about this lawsuit and what it means going forward. But in order to understand this lawsuit, we need to understand who Defense Distributed is and what they do. Defense Distributed is a firearms manufacturer based in Texas, but they're an unusual firearms manufacturer. Most firearms manufacturers, like bigger names you might have heard of, Colt, Remington, Beretta, produce a final firearm, a final product that you can purchase in a gun shop. However, Defense Distributed doesn't produce firearms in this way. What they produce is something else instead. They produce specialized 3D printers which are suitable for printing firearm components. Off-the-shelf 3D printers are typically unsuitable for this purpose. Firearms, as I'm sure you can appreciate, produce a lot of heat and a lot of vibration. And standard plastics that are used in off-the-shelf commercial 3D printers that you can buy for relatively inexpensive prices use plastics which are unsuitable for this purpose. The firearm going off will tend to explode the firearm itself rather than keeping the explosion contained in order to make the projectile go where you want to go. And they tend to fail relatively quickly. So Defense Distributed produces specialized 3D printers. While they can produce anything, they are designed to produce firearm components. The materials that they use in the 3D printing process are more durable and tend to last longer. While it is unlikely that it is as durable as metal that would be used in a typical firearm, the reinforced plastics that Defense Distributed use are capable of producing a firearm which is capable of repeated use. The ability for someone to make their own firearm in their own home does run counter to any sort of desire for firearms regulation, because firearms regulation usually deals with point of sale at a firearm shop, background checks, and that sort of thing. But if someone can make their firearm components themselves in a way that is not detectable by the United States government, then this sort of defeats any possible gun control that could be passed. As it happens, this is actually Defense Distributed's point. The person who runs Defense Distributed is a person named Cody Wilson. Cody Wilson is, by his own admission, an anarchist. His desire is to produce equipment and instructions that can enable any person to make their own firearm components, to prove the futility of any firearms regulation. His design and purpose is specifically to thwart any firearms regulations that could even theoretically be passed. So this is not so much a bug from Defense Distributed's point of view as a feature. The way the United States government got involved in this is quite interesting. The State Department contacted Defense Distributed back in 2013. In 2013, Defense Distributed published on their website CAD instructions and other instructions that would enable then off-the-shelf commercial 3D printers to print firearm components. The reason the State Department got involved was because their website was not secured. Anyone could log onto their website and download those instructions. And the State Department felt this violated what's called ITAR regulations, International Traffic in Arms Regulations. Under ITAR, which we'll get to in a little bit more detail later, the United States government controls arms and arms-related munitions in terms of what can be exported and what not. If you're a major firearms manufacturer, in order to export something, you have to go through a much more lengthy process to comport with ITAR regulations. But Cody Wilson and Defense Distributed didn't do anything like that. They just posted the instructions for anyone to download on their website. Because the instructions related to firearm components, namely how to build them, the United States government took the position that these instructions, because they could be downloaded by anyone in the world, therefore being exported, violated the ITAR regulations. As a result of the State Department's activities, Cody Wilson and Defense Distributed sued the United States State Department, arguing that their taking down of computer code was unconstitutional prior restraint. Under United States First Amendment law, the United States government cannot, in advance, prevent someone from saying something. That's called prior restraint. The First Amendment protecting freedom of speech forbids prior restraint, And Defense Distributed took the position that the ITAR regulations were a prior restraint because it took down anything they would want to publish with relating to this matter. This lawsuit has been going on for a couple of years, and although no final judgment was actually reached in the district court, it seemed that the United States government was going to lose. And so the United States government, rather than having a judgment put against them and setting the precedent, came up with a settlement agreement. According to the settlement agreement, the government acknowledges that non-automatic firearms up to .50 caliber, including rifles such as the AR-15, are not inherently military. That's important because ITAR regulations only relate to military firearms. The United States government saying that the AR-15 and similar firearms are not inherently military is an important concession because by saying that, it takes them definitionally out of the ITAR regulations. So far, we have talked about the main two parties in this litigation, Defense Distributed and the State Department. But there was a third party, someone who was supporting Defense Distributed, and that person was the Second Amendment Foundation. The Second Amendment Foundation is a pro-gun rights organization in the same way that the National Rifle Association, NRA, is. The NRA, of course, is much more notable. And the NRA is much more notable because they involve themselves in so many more types of affairs. The NRA involves themselves in everything. They deal with lobbying, they deal with politics, they deal with drafting legislation, they deal with firearms training. They are involved in everything. And they maintain a much more public front as a result. But the NRA is not the only pro-gun organization that there is. There are other ones, such as the Second Amendment Foundation. While much smaller by membership, the Second Amendment Foundation is also much more focused in its efforts. The Second Amendment Foundation is the organization which is most dominantly involved in lawsuits relating to the Second Amendment rights. In fact, it was the Second Amendment Foundation, not the National Rifle Association, that brought the lawsuits that ultimately resulted in Heller versus D.C. and McDonald versus Chicago, the cases that established the Second Amendment right about 10 years ago. The Second Amendment Foundation is much more notable for their litigation activities, but because they don't deal with politics and only deal with the law, they don't maintain as much as a public presence, so they are not as notable. However, they are more consequential as it relates to the development of law than the NRA because of their specific focus in this area. All this discussion that we've had so far may have caused you to ask the question, hey, is it legal for you to make your own firearm in your home? Don't you have to go through some kind of background check in order to buy a firearm or make a firearm? Well, let's ask the ATF, the Bureau of Alcohol, Tobacco, and Firearms, which deals with firearms regulations, what the law is on this matter. This is on their webpage, and they have a fact on this that says, does an individual need a license to make a firearm? No, a license is not required to make a firearm solely for personal use. However, a license is required to manufacture firearms for sale or distribution. So it is completely legal for a person to make their own firearm in their own home. No background check, no serial number. As long as you're making it for your own personal use and it's not made for the purpose of sale or distribution, it is completely legal for a person to make their own firearm under United States law. This may come as a surprise, but this has been the law for quite some time. The United States State Department felt that they had the ability to regulate the publication of the technical data under this section of law. This is from the Code of Federal Regulations. This is 22 CFR 121.1 if you'd like to look it up. And according to this, in Section A, technical data is designated as a defense article. So technical data is data which describes firearms. And it's further clarified down in Part 2 of this paragraph down here, where it says that technical data related to manufacture or production of a defense article designated as significant military equipment is also designated as significant military equipment. So significant military equipment itself is regulated, but so is the technical data that describes its manufacture or production, which is exactly what Defense Distributed was doing. That's why that provision in the settlement agreement that says this is inherently non-military is so important. But behind the United States government agreeing this is inherently non-military, the United States government is by definition saying that this type of technical literature is excluded from these provisions of the Code of Federal Regulations and is therefore illegal for a person to publish. On screen now is a copy of the settlement agreement that was reached between the parties. This is between Defense Distributed and the United States Department of State, which regulates the exportation of munitions and other firearms-related technology. and we're going to cover the major provisions of this litigation. First, in Section A, the United States government agrees to publish a draft rule and propose for rule change according to the Administrative Procedures Act, which will change the rules in the Code of Federal Regulations to exclude all the technical data that is the subject of this action. While under the law as it's currently written, any non-military equipment is not covered under the regulation, Defense Distributed was able to get the United States government to agree to make a more affirmative statement in the Code of Federal Regulations so that this dispute could not arise again in a similar situation. In Part B of the settlement agreement, Defense Distributed also got the United States government to agree to publish an immediate temporary modification to say that this technical data is excluded from the protections of the Code of Federal Regulations. Most provisions of the CFR give the Secretary of the related agency the authority to waive a rule if deemed necessary, and this is no different. There is a provision in the ITAR regulations which gives the Secretary of State the authority to waive provisions if deemed necessary. So although a formal rule change will be made, in the interim, the United States Secretary of State has agreed to publish an immediate rule that says that this is waived pending the rule change. Under Part C, the United States government also agrees to send to Defense Distributed a signed letter stating affirmatively that the previously published files, the Ghost Gunner files, and the CAD files are approved for public release, unlimited distribution in any form, and are exempt from export licensing requirement because they satisfy the provisions of law relating to this kind of publication. In Part D, the United States government agrees that this rule change means that any United States person, including yours truly, can access, discuss, use, reproduce, or otherwise benefit from any technical data that is the subject of this action, and permits any person to use, discuss, or reproduce, or otherwise benefit from the files. So you and I can discuss this freely, and we can publish the files freely and redistribute the files freely without any regulations or concerns for ourselves. And perhaps most notably and most interestingly, the United States government has agreed to pay Defense Distributed almost $40,000 in monies. It's a little unusual for these kind of settlement agreements to have the United States government agree to give monies, but this is relating to at least some of the litigation costs. The idea here being that the United States government was making improper prior restraint, and under the United States law, because of that, they could have been sued for the related monetary fees anyway. So they are agreeing to pay at least some of the fees. Cody Wilson could have probably held out for more. The total amount of fees has been rated as significantly more than this, and I have no problem believing that given how long this litigation has been ongoing. But in order to get the settlement, which gave them everything that they wanted in terms of the substance, they agreed to a relatively smaller monetary payment, which I think was a smart course of action, at least as far as Defense Distributed's interest goes. This provision of the settlement agreement helps to define some of the terms more specifically in terms of what can and can be not published. In terms of this, what cannot be published in terms of what remains military equipment is any sort of magazine that has a capacity of greater than 50 rounds and specifically defined components for that, parts specifically designed for conversion of semi-automatic to fully automatic, which incidentally is illegal unless you pay a specific tax stamp, which is somewhat difficult to get, and accessories or attachments designed to automatically stabilize a gun in terms of automatic targeting or automatic aiming. So this settlement agreement says that standard magazines, standard rifles, including AR-15s and their standard components can be published. What cannot be published under this is military equipment. And military equipment is defined to include magazines of a capacity greater than 50 rounds, anything that helps to convert a semi-automatic to a fully automatic, and anything that would help to automatically aim a firearm. It also affirmatively states that what can be published is the technical data, and technical data includes the previously published files, the Ghost Gunner files, the CAD files, which are the instructions for the printer, and other files insofar as those items relate to what had previously been banned on the United States munitions list relating to barrels, receivers, and other components or items that are now excluded as military equipment. And here we can see the signatures from the respective parties. We have the signature from Cody Wilson's attorney, and most notably, the signature from the United States Department of Justice, which represents the United States government in all civil litigation. So this is a binding agreement that has been agreed to by the United States government. Some of you may feel that it's very weird indeed for there to be instructions on how to make firearms that are considered to be legal. But as it happens, this is not the first time the United States has dealt with something similar to this. I would like to reference the Anarchist Cookbook published in 1971. This book also published instructions on how to make dangerous things. This book included instructions on how to manufacture explosives, how to make machines that would allow you to hack into telecommunications device, which in the parlance of that field is called phreaking, and how to build weapons, as well as how to manufacture illicit drugs, including LSD. This book was published in 1971, and although its legality has been questioned in several jurisdictions, it is fully legal in the United States. Because although while it is illegal to manufacture LSD, it is not illegal for me to tell you how to manufacture LSD. It is fully legal for me to tell you, and for the Anarchist Cookbook to tell you, how to manufacture an illicit drug, or how to make illegal weapons, or how to make explosives. While it may not be legal to actually do any of those things, the instructions themselves are speech. And under United States First Amendment law, only speech relating to imminent lawful action is considered prohibited. Because the speech in question is merely providing instructions on how one might do it, it is not considered imminent lawless action. So, although it may seem strange that Cody Wilson can publish instructions on how to build a firearm, this is not the first time the United States has dealt with something similar. The United States has dealt previously with books that provide instructions on how to do potentially illegal things, but under United States law, this has been considered fully legal. So, this is not exactly unprecedented in terms of the United States First Amendment law. This settlement agreement relates to a very interesting intersection of First Amendment and Second Amendment law. The ability for the government to regulate firearms under the Second Amendment is still very much open in the air. Under Heller versus DC and McDonald versus Chicago, we know that those arms which are in common use, such as common handguns, are allowed to be maintained in one's home under the Second Amendment. But the United States Supreme Court has not provided any meaningful case law since then. It is unclear the degree to which the state can or cannot regulate the Second Amendment, although it seems likely that they're able to regulate it to some significant degree. However, unlike the Second Amendment, the First Amendment is much more well established in United States law. For about 80 years, there have been numerous First Amendment cases which have very specifically delineated what is and is not free speech under United States law. And code and instruction such as this has been held to be speech, which in and of itself should not be unusual. Code, after all, is a language. It's written in an unusual language, one that may be difficult to read, but it is a language nevertheless. And even though it may be providing instructions on how to build firearms, instructions even on how to do illegal things is not in and of itself illegal under United States law. The restrictions of ITAR that said the United States government was prohibiting the exportation of these instructions has been agreed upon by the parties to be improperly restricting free speech. So it's a very interesting intersection of First Amendment and Second Amendment law, specifically because Cody Wilson, as an anarchist, his design is to enable people to make firearms that would circumvent U.S. law because you make them themselves. They do not have a serial number. You do not have to go through a background check, and there's no registration of the firearms. So Cody Wilson's design is to circumvent any sort of Second Amendment regulations that might be put in place, even if those regulations are otherwise proper, by using the First Amendment to accomplish that purpose. It's a very interesting intersection of two amendments of law, and it relates to how these things can interact in unexpected ways. So that, my friends, is the story of Defense Distributed versus the United States government. So come August the 1st, just a couple days from now, you too will be able to download CAD instructions to build common firearms in 3D printers, and you'll be able to buy the specialized 3D printers from Defense Distributed for that purpose if you are so inclined. Until later, my friends, that's all for now. Cheers. Bye.